SJC-12005, Commonwealth v. James S. Winquist.
Thank you.
Wait one moment. Okay, we welcome our guests as well as the sign interpreter. Who is to be the sign interpreter? You are, okay. Sorry, there'll be two of you, okay. And do you have enough room to do that? You're fine? Okay. That, Ms. O'Brien, you may begin.
Good morning, Your Honors. May it please the Court. Leslie O'Brien for James Winquist. I realize that the Court knows that this was a particularly shocking murder that was committed in this case, that there were two innocent victims who were brutally beaten to death. And when the Commonwealth speaks of the brutality and the horror of this case, I have nothing to say in rebuttal to that. But what I will say is that this was far from an overwhelming case against Mr. Winquist. And that's important here because if there were any errors in the case, those errors cannot be or should not be seen as harmless or non-prejudicial.
Far from overwhelming in the sense of his personal involvement as opposed to his presence during the murders.
Exactly. Exactly my point, Your Honor.
If we could turn to the first statement that was made on the night of the murder as they were trying to get rid of the bloody clothes.
Yes.
Judge found that when Snow told the defendant that he made his bones, that was intended to demonstrate their solidarity and the importance of retaining silence. Is that not in furtherance, or is an abuse of discretion for the judge to have made that finding, given that it was I guess, only hours after the killing?
Well, I'd suggest, Your Honor, that was certainly closer in time. The stronger argument regarding that, and the argument that I've made, is that this statement cannot be said to have been made in furtherance of the crime. It's directly saying that it's in furtherance of the crime is directly contradictory to Commonwealth versus Stewart, which is one of the cases I had hoped to speak about today. It's a bragging type of statement. It's made in front of a third party who, at least according to the Commonwealth's theory, was not directly involved in the events.
But couldn't it be interpreted, though, as Chief Justice Gans is saying, as a statement? And I thought this is what the judge was saying. It's a statement on the part of the now deceased, what's his name?
No.
Eric Snow.
On the part of Snow to your client, saying, kind of bucking him up, you're part of this group, so be quiet. I mean, couldn't it be interpreted that way? It's a compliment. You've done something that shows, you're worthy. You're part of us.
Well, I realize that's a theory that was offered. It doesn't get around this problem, this Commonwealth v. Stewart problem, where there was a third individual present who was supposedly not involved in the joint venture. But I'd also suggest that the court stated earlier that there's a reason for a rule, and it occurs in the court in the types of this type of. Sometimes a reason becomes a rationalization, and I'd suggest that this type of speculation that this was offered. Well, Eric Snow must have been offering this to keep loyalty, to make sure that the defendant participated in hiding the crime. It's speculative. It's stretching this rule. And what I'm urging here, what I'm asking the court to do really is to adhere to the rule literally, to stop the stretching and the spread of the rule beyond what it was originally intended to cover.
But the standard of review, I mean, the judge, Judge Chin, had to make this decision at trial in a short moment of time.
Yes.
Don't we review his factual determination that it's in furtherance by the abuse of discretion standard?
Yes, and what Judge,
So it has to fall outside of the, I forgot what the precise language of LL, but it has to fall outside the realm of,
and here the judge stretched the rule far beyond any use of the rule that had ever been before.
Do I understand this? We're using furtherance. I take it we're not using conceal for a reason, because it's not conceal. So I thought furtherance was what you did before the formation, and that's what you led in to see that the joint venture was thereafter formed, as compared to conceal, which is after. So you're arguing that this was a furtherance or a conceal, not a furtherance or not a concealing, or neither one?
I may have been confusing the two statements, not in furtherance. The Kelly Burgess, the statement that was attributed by to the defendant, to Mr. Snow by Kelly Burgess,
After.
I say was not in furtherance. And also, in regard to this Kelly Burgess statement, I'd ask the court to consider the relationship between the two statements. Kelly Burgess was referred to as the critical witness by the Commonwealth in their closing. Kelly Burgess admitted that she suffered from mental illness. She admitted, even though she balked at the word, that she had perjured herself not once but several times in front of the grand jury. So I'm linking the matter of the two statements because it was so important to the Commonwealth. The Commonwealth spent nearly the entirety of its closing argument attempting to bolster and corroborate Kelly Burgess, and that's why there's such a strong link between that Kelly Burgess statement and the later statement. The tendency of that later alleged statement in the letter to bolster Kelly Burgess's statement was critical, so that later statement, even if the court were to determine...
The later statement was from Snow, the deceased co-conspirator here, to your client, essentially to kill Kelly Burgess. Or am I missing?
Well, I'd say respectfully that you're mixing two different things, Your Honor. There were statements in the letter about we want to kill witnesses. Statements. I'm certainly not saying.
And Kelly Burgess being a witness, and wasn't it her house that your client was going to burn down?
Wasn't she the one that he said should be underground or something?
That was the allegation. That was the allegation. I'm sorry, Your Honor.
That's not in the letter?
And I'm certainly not saying that evidence that if there's credible evidence that a defendant was wanted to kill witnesses or was participating or discussing killing witnesses, that certainly there's an argument that there's consciousness of guilt, that those types of acts of concealment, there's always going to be the argument that those are admissible. What I'm saying was not admissible is the statement, you made your bones, you made your bones.
Now, the
That's a
statement in the
direct
letter or the
accusation of
statement?
guilt.
The statement, I'm sorry, is this the statement in the letter or the statement to Burgess?
The statement was made 3 times. Twice to Burgess, twice according to Burgess. She claimed in her testimony, it was elicited from her twice. Then it was elicited from a state trooper who read it from a letter that was enlarged on a board, marked in evidence, and sent into the jury room. You made your bones, a direct accusation of guilt offered for the truth of the matter asserted.
In which Snow encourages the defendant to kill Burgess?
According to the
Is that the same letter? That's the question I'm asking you. The one that you just said was blown up, is that the same letter?
There are statements encouraging that witnesses
encouraging
need to be
him
taken
to
underground.
kill Burgess?
Yes, it's in the same letter.
Okay,
It's-
and we know that he, in fact, went to Burgess's house to try to do that.
That was the testimony at trial,
It-
yes, Your Honor.
do you think it was improper to admit the testimony of his trip to the house where Burgess was living and the conversation between him and Alfano, or whatever his name?
No, that's the distinction I'm making, Your Honor. I'm saying that evidence of concealment is one thing. Evidence of concealment, because it's, at least under the theory of consciousness of guilt, it's potentially going to be admissible.
Let me make sure I understand. I think what you're saying is you're not challenging the other statements in the letter that asked him to kill Burgess and Amaral and Beast, to silence them, probably because they're not offered for their truth. They're offered simply to say, go do this, which he ultimately then went, apparently, potentially to do. You're challenging only the statement that said you made your bones while the rest smoked them, because that is offered for the truth of what happened in the past.
Exactly. That's exactly my point, Your Honor. And this statement, this was really, there was nothing from the defendant that was nearly as inculpatory or incriminating as that statement, you made your bones. The defendant made no admissions that come close to that. In fact, I'd suggest there was no other evidence in the case that came close to as incriminating as that. You made your bones. You killed the victim. You're a cooperator in this terrible crime. If you look at the evidence, you can definitely see why the prosecutors were so intent on getting that information before the jury. If I can just return very briefly to my point about the weaknesses in the case, about the case not being overwhelming, it's not just the problems with Kelly Burgess that indicate that. This was a case where the jurors rejected the Commonwealth's theory of guilt. If the jurors had accepted the Commonwealth's theory that Mr. Winquist went to Bear Cove Park to beat these victims to death with terrible implements, surely the verdict would have been guilty of first-degree murder on both theories, premeditation and extreme atrocity and cruelty. The jurors rejected that. The jurors deliberated for more than 2 full days, and they clearly rejected that theory. And I'm stressing that for the reason that if the court finds error, as I'm urging the court to do, then the error cannot be seen as, the error could easily have tipped the balance. This could have been a verdict of acquittal, but for these statements that were erroneously admitted in this case.
But participation in the crime need not have been to take a bat and strike them. His participation could have been to be assisting there, he was there with them. Wouldn't that be enough to say he aided and abetted? There was blood on his clothes. There was no indication that he was seeking to restrain him. It is a pretty, wholly apart from whether or not he also struck them with the bat, but he was certainly with Snow when all this happened. He left with Snow, came back with Snow. There was no indication of regret. Don't you have aiding and abetting there?
There was evidence that he was with Snow. The contested point was whether he participated, or whether there were statements made. There was testimony that he told someone else that he got there, couldn't go through with it. That he and Kelly Burgess ran away at that time. What I'm really asking of the court is to adhere to the court's precedent, particularly recent precedent regarding this rule. And I'd suggest that the precedent, particularly the recent precedent, is clear and offers good, firm guidance to the lower courts regarding how this rule should
What
be
in
applied.
particular are you, which cases in particular are you relying on?
In particular, I'm relying on Commonwealth versus Braley, Commonwealth versus Stewart, and Commonwealth versus Bright. And those all relate to statements of concealment made shortly after the murder. In fact, that very phrase, shortly after the murder, is used in both Stewart and Bright. So these requirements that the.
But don't you think that was driven by the facts of those cases? That that's just happened to be, that it was shortly after, as opposed to that it could only be shortly after?
No, Your Honor. I think that is, if you look at the way that the time period has expanded in these cases, it's significant. Going back to Commonwealth versus White, which I believe is 1970, Commonwealth versus White suggested that statements made during an escape immediately after the crime might be admissible, and then it's gradually been expanded. So we're talking about days or weeks.
But, I mean, I thought, you know, the arguments, at least that the timing goes to the second you made your bones. You can't make a timing argument as to the first, I don't think.
No, it's the in furtherance argument. It's the Stewart argument.
So it's the ambiguity. Is that what you're saying? That we cannot allow in statements that are ambiguous? Because I think you
No.
said, but I think you sort of agreed that one could interpret it in this way of that it was meant as a concealment statement.
I'm saying that that's quite a stretch to let in a statement, a hearsay statement, you killed somebody. That's a rationalization. It's not a reason. If I could just, in one sentence, address, it's been suggested this might have been offered, that some of these statements might have been offered as motive. They weren't offered as motive. The judge did not restrict the statements in any way. They were offered for their truth, and the jurors were instructed regarding the rule concerning co-venturers' statements only. Thank you, Your Honors.
Good morning. May it please the court. Mary Lee, Assistant District Attorney from the Plymouth District for the Commonwealth. The defendant is claiming that the admission of two statements of the defendant's co-defendant or co-venturer, Eric Snow, were inadmissible. Those statements say the same thing. You made your bones. The first statement was made within, according to the testimony of Kelly Burgess, probably within an hour, no later than 2 hours after the murders had occurred. And the second statement was made in a letter to the defendant that was celebrating the second anniversary, 2 years after the murders.
So if it were to be charged as a conspiracy, the conspiracy, you say, would extend for 2 years afterwards?
Well, I would suggest in this case, the conspiracy extends for 2 years afterwards because there was evidence that they had indeed explicitly agreed to continue, and that would be that in that second letter. And if I could just stop for a minute and point out, you can find the content of the letters in transcript 8, pages 56 to 60, and that also indicates on page 55 that those are the letters that are blown up. So you can read them for yourselves. My belief is your understanding of the content of the letters was correct from your questions to my sister.
So you say, yes, there was evidence that the conspiracy continued for 2 years?
Yes.
And that evidence was the letter?
Well, in that letter, Eric Snow, the deceased co-defendant, is saying, you know, these people are out to get us, and they want to see us go down for eternity. Actually, it starts with, do you read me, comrade? They want to see us go down for eternity. I don't know about you, but I would give up my life right now to get my hands on some of this human filth. And then he starts telling them, you know, putting in how you can find Kelly Burgess so that you can't miss that house.
So
And
the
then-
idea is that if you look at the content of the letter proves the conspiracy continues. And it's as a result of that
No.
you can get in the bones?
No,
statement?
joint venture has to be proven through information outside of the other statements. And so you look at what the defendant did in this case. The defendant went to Burgess's house. He gets caught by Burgess's boyfriend, Amaral, and he says, I'm here because Eric Snow sent me to burn down the house. So we have a defendant's admission, which is substantively admissible, and he is admitting that this is continuing, that this conspiracy.
He says, but I can't do it. So
He said, well, he got caught. Amaral was,
Oh, before
was
that,
a
he
drug
didn't.
dealer who was watching police surveilling his house. And he sees with his binoculars that
You take something out of his car,
Eric
but then he
Snow is
doesn't
bringing
bring
the
it up.
bucket up.
But he
And he
didn't bring
stops
it
him
up.
on the stairs and brings him up the stairs, and what are you doing here? And the defendant says, Eric Snow sent me to burn down the house. And then you can see the discussion between the defendant and Eric Snow and their telephone calls that are in the Commonwealth's record appendix that talk about Snow saying, why'd you tell him I sent you there? And of course, we have then Eric Snow's letter saying that he was indeed saying, which is not hearsay, you're correct, it's saying, go take care of this witness. Burgess needs to be under soil. She's been calling my mother. She can't be trusted anymore. She's an alcoholic. She's a drunk. She's a liability. They want to see us go down for eternity. And you combine that in the context of this joint venture, because I agree, the Commonwealth had the burden to prove by a preponderance of the evidence that the joint venture existed and was continuing by evidence outside of the statements of Snow. We did prove that, because first we showed that they are members of the Brotherhood of Blood. They joined together to cooperate and further their own interests and protect each other. And to prove yourself to be part of this brotherhood that existed long before these murders, you had to do something to prove yourself worthy to make your bones. And you make your bones by killing someone. They go and do this crime, and 2 years later, the defendant himself is saying that I came here because Snow sent me to burn down this house. And further, you look at his statement to Caitlin Glynn. Caitlin Glynn is a bit of an outsider. Her friend dates one of the members of the Brotherhood of Blood, or someone connected to that. I forget the exact relationship. And she finds out that Eric Snow has gone to jail. And she says, oh, is that because of the Bear Cove Park murders? As you recall, the Bear Cove Park murders involved a man's hand being cut off. And of course, the Brotherhood of Blood had possession of that hand, and it passed around at parties as a joking trophy, a comical souvenir that they would use to shake hands during their parties. So that's how Caitlin Glynn knew about the Bear Cove Park murders. This was well known within their group. So she says to the defendant, is that why he went to jail, the Bear Cove Park murders? And the defendant says, no, if that were true, then I'd be, and excuse my language, I'd be fucked too. So it is the defendant himself who is foreseeing that this is a continuing joint venture. It is the defendant himself who is acting on the request of Snow. It is the defendant himself who linked himself. I am not saying that in every case, or even every joint venture murder, that joint venture hearsay carries on into eternity. I'm saying it can carry on into eternity because you are liable to be charged because there's no statute of limitations.
But let me make sure, I mean, it gets a big issue. You know, the U.S. Supreme Court in Krulwich was concerned about the extension of the statute of limitations. And I know that's not an issue here, but the principle arguably could play into cases where there is a statute of limitations. So is it your argument that where there is affirmative efforts to destroy evidence or kill witnesses, that separates this from the ordinary case?
I'm saying where there's affirmative evidence that the joint venture is continuing and there are statements made in furtherance of that continuing joint venture, then the time period is not significant. And that's what Stewart says. It's not about time. It's about whether the venture is continuing. So I would point out that Grunwald and Krulwich have also been explained. In Ingram, it said those cases hold only that the life of the conspiracy cannot be extended by evidence of concealment after the conspiracy's criminal objectives have been fully accomplished. And then Dutton versus Evans notes that state murder cases are not governed by that rule. In the case before us, such policy questions are not present. Evans was not prosecuted for conspiracy in the Georgia court, but for the substantive offense of murder. This case does not come into the range of Krulwich and Grunwald and Dutton because, one, murder has no statute of limitations. Two, there's no attempt at an end run around a statute of limitations or an inappropriate attempt to extend the conspiracy or joint venture that was the concern in Grunwald and Krulwich. And finally, here we have an explicit agreement to conceal. What those cases were worried about is that after you've committed a crime, whether it's with somebody or without somebody, you're going to take steps to protect yourself, and that you should not be implying an agreement from an individual's actions that happen to help somebody else. We have an express agreement.
So, okay, if I accept that, but what about the ambiguity of this statement? I mean, what does it mean? And is it fair, particularly 2 years later, whenever that is, to use a highly ambiguous statement against the defendant? I mean, it seems to me, and correct me if I'm wrong, but certainly from the defendant's perspective, or it is argued by Ms. O'Brien, that this is really the only real evidence that he, not that he was there, but that he was a real player, that he actively participated.
I have two answers to your question. The first answer is that this isn't ambiguous. The Commonwealth defined what major bones mean. It's at transcript 4, 195. It means to kill somebody, work to prove that you're worthy.
Yeah, but this is the other
brotherhood.
guy saying it to him. That's what I'm saying.
Right,
maybe.
and then again, a person who's even not part of Courage, who's not part of the Brotherhood yet, he's a wannabe. It's transcript 7, pages 47 to 48. So the jury could tell what that means. So when you have that claim of, oh, this could mean something else, you look to Commonwealth versus Pike and Commonwealth versus Crua. The doctor in Pike is a defendant charged with unlawful distribution of narcotics, and he says he's the local drug pusher. He's like, oh, that was a joke. I write prescriptions, it's a joke. And what this court said in Pike is, that's for the jury to decide whether it's a joke or not. It's for the jury to decide what local drug pusher means. And the same in Crua, the defendant's apology. Does that mean the apology encompassed the rape? That's for the jury to make that determination.
But can I just, I thought I heard a distinction trying to be drawn between the statement in the letter about you made your bones and the other statements in there about, killing Burgess and that the latter might certainly be seen as in furtherance of the conspiracy because that would be an attempt to conceal.
The defendant's...
The you made your bones could be seen as sort of this extraneous statement, which was not really, how did that help to conceal or further the crime?
Well, the defendant's only challenging the major bones part, and the major bones part would be hearsay versus the others, which are directives.
Right.
But I would suggest that it does further it because it's in celebration of the murder. I think you must remember how this conspiracy and how these murders take place. In most crimes that face us, we see people committing a murder and then they're committing a crime, and then they're trying to cover up the crime, and that's where you see the joint venture forming. In this case, this had gone on, this brotherhood had existed, and the murders, as awful and horrible as they are incidental to the brotherhood. The reason for the crime is the brotherhood. They do it to prove themselves that they're worthy. And so this celebration of, you made your bones, and this statement, you made your bones while the others smoked them, that the judge is absolutely right in his finding that this is emboldening the other members of the joint venture. And that is something that we as a court, you as the court and we as the Commonwealth acknowledge in our case law, that these lookouts or these people who are urging crimes or these people who are outside of the actual action of the crime but are causing the crime, they are as guilty under Zanetti as the principal. In this case, the judge notes this is emboldening them. This is a congratulations. This is a celebration. Snow wants something from the defendant in this letter. Go out and fix this problem. I'm looking for some leadership for you. She needs to be taken under soil. You made your bones while the others smoked them. Now go handle this. And the defendant does it. And I would suggest that this letter is cumulative of what happened on the night of the murders. And what happened on the night of the murders in the You Made Your Bones is classic joint venture hearsay. The fact that Burgess was there makes it no different from the statements in Braley. You recall the Braley case is a shooting, 2 men. Alibord's the driver, Braley's the shooter. They go back to the house that they each have an apartment in the house, and they talk about the crime in front of their wife and girlfriend. And that's the statements that came in. I was driving, he pulled out the gun, he shot him, it's my gun, it's my truck, what are we gonna do? And then 10 days later, we all agree not to discuss this again so we don't get caught. That's Braley and Alibord. How is that any different? In fact, this case is better for Burgess being part of it because it's her car. She drove them there. She drove them back. She watched them change their clothes, their bloody clothes. She heard them say, "You get rid of the bats, and I'll take, I'm gonna go. You made your bones." And then she watches as Snow hides the hand in a hole in the ground. She's part and parcel of their plan. She's so much more involved than the people in Braley and Alibord. This is, the first statement's classic joint venture hearsay, and the second statement is at least cumulative of it, but I suggest in this court, in this case, the judge was absolutely right in finding continuing.
She was not charged.
She was not charged.
Does it make a difference here that, as you've sort of pointed out, that there's the joint venture to conceal the crime, the particular killing here, and there's also a joint venture to embolden others to become members of the gang and continue on with this killing spree, or with other killings. Are they two separate and distinct joint ventures?
I would suggest no. I think the trial judge found there were no. I think the appeals court looked at it differently and found two separate joint ventures and found that the second joint venture, akin to a prior bad act, would be relevant to show a subsequent bad act would be relevant to showing people's intent. I think either is correct. I don't think you need to go where the appeals court went because this is a continuing joint venture.
Well, isn't it more than that? I mean, the jury has to accept this as being in furtherance. I assume the jury was not told that they need to find a second separate conspiracy in order to admit this.
They were properly instructed on joint venture hearsay, and I would
Oh, as to a single
as to
joint
single
venture.
joint
So-
venture. And so we know that the jury found that the
Right.
joint venture was continuing
but-
and that these statements were made in furtherance of it.
But is it
from
fair
that.
to say that we can't go where the appeals court, we can't go the way the appeals court went because the jury was never asked to make that determination?
I think you could, but I don't think you have to.
How could we?
I think you could because you could look at it as a subsequent bad act in covering up the crime and therefore would be relevant to show motive and state of mind and therefore wouldn't need any more specific
wouldn't be
instruction than the
hearsay?
joint venture
Would
instruction.
it be hearsay at that point or not?
I think it would still be joint venture hearsay. But at any rate, I would suggest that there is no prejudice from the second statement. The first statement is classic joint venture hearsay that is admissible. The defendant made statements to Alfano, Courage, and Glynn as to his complicity. He was seen going to and from the murder scene with Snow from Burgess's testimony. He had blood on him from Burgess's testimony. He hid the weapons in the clothes. He described to Courage, look what's missing, the saw and the bat. And finally, the classic joint venture hearsay of the oral statement on the night of the murders. This evidence is overwhelming against the defendant, and I would ask this court to affirm the convictions for both murders in the second degree.
Thank you. And we'll take our morning break.